Okay, members, I understand Senator Clark's got an amendment. Do you also have a verbal amendment?
I do, Senator Hendren. If it's okay, I'm going to remove my mask so y'all can hear me while I'm presenting the bill. The amendment is simply adding sponsors, and I'm going to ask you to suspend the rules because we have two more sponsors, Senator Jason Rapert and Representative Cindy Crawford, that were not on the amendment when it was drawn up. And so if y'all don't mind.
So your motion is to suspend the rules for the purpose of adding these three as sponsors?
Correct.
Is that a motion by Senator Stubblefield? Second. All in favor say aye. Okay, so now to approve the amendment. Do I need a motion to approve the amendment? Got a motion by Senator Stubblefield, second by Senator Johnson. All in favor say aye. Amendment is adopted. Senator Clark, you're recognized to explain your bill.
Looks like I've got lots of amendments and no bill, Mr. Chair.
Headed your way. You don't have it memorized?
Did we just adopt his amendments that added sponsors? Is that what we just did?
Yes, ma'am.
And he's saying now that he has other amendments?
No, ma'am. Now we're going to talk about the bill.
Okay.
Yeah, you gave it to me. All right, thank you, Mr. Chair. The really substantive part of the bill is beginning on line 22 on page 1. In an action for divorce or an action to modify a child custody order, there is a rebuttable presumption that joint custody is in the best interest of the child. The presumption that joint custody is in the best interest of the child may be rebutted. And then it goes on to say how it may be rebutted. And there's a couple things I'd like to tell you about that, why we're bringing this bill. And for me, it's about the need for fathers in the raising of children. Children need both their parents. Children need fathers, they need mothers. And it is sad in many cases that sometimes one parent is not fit. Sometimes, because I work very much with the child welfare system, sometimes neither parent is fit. But it doesn't do away with the fact that children need their fathers and mothers. And I'm reminded many years ago when we had the school shooting at Jonesboro, a young contractor was in the store, a friend of mine, speaking to me, and he said, I hope that neither one of my sons ever would do anything like that. This really scares me. And I said, Aaron, you don't have to worry about that. It's not going to happen to you. And he said, how can you say that? And I said, if you look at the statistics, and the statistics have continued to be true since that time, that it rarely happens where that you have such a tragedy like that, where there has been an active father in the home. And again, I'm not downplaying the role of the mother. My mother has played a wonderful role in my life. But there is a great disparity in our system between fathers and mothers. From the day a couple splits and my watching the system, there is a great difference in custody between the two. Because of that, in 2013, this legislature passed a law that said in an action for divorce, an award of joint custody is favored. And that's in Arkansas per 913-10A. And I'm reading that from a handout that I gave you that is from the Arkansas Circuit Court Judicial Bench Book, Domestic Relations, updated June 2018, page 75. And they're under joint custody. You have it, but I'm going to read it to you. When in the best interest of a child, custody shall be awarded in such a way as to assure the frequent and continuing contact of the child with both parents. To this effect, the circuit court may consider awarding joint custody of a child to the parents and making an order for custody. In an action for divorce, an award of joint custody is favored in Arkansas per the law that we passed. Y'all with me? Now let's keep reading. However, case law, both before and after adoption of code provision above, indicates that joint custody is not normally favored unless circumstances clearly warrant such action. Now, did y'all get that?
Excuse me, are you reading from a statute? You referenced a statute that you're reading from.
Mr. Chair, if I could finish, but I will answer the
I'm trying to follow him.
I understand. Do we have a way to get rid of this document?
What document is he reading from?
All right, Senator Flowers, let's go ahead and follow the protocol, ask him questions and so on, but we are going to email and text you this document, and Senator Clark, if you would explain exactly what this document is so that Senator Flowers is clear on it. And Senator Flowers,
he said he was reading from the statute, and that's not in the statute.
All right, just a second, Senator Clark. Okay. What's your point of order?
Thank you.
We have a protocol that we follow here.
Right.
Senator Flowers is about following that protocol.
All right, Senator Flowers is participating remotely, and we're trying to get her the information that we have available here. So we're in unusual times here. So
if he could just identify what he's reading from.
Senator Clark, while we're sending that to Senator Flowers, would you explain more clearly what this document is? And Senator Flowers, if you just go ahead and ask to be recognized and try to follow the protocol. I know it's remote and it's more difficult, but.
Are you all emailing me this? Whatever this is?
We're going to text it to you right now. Okay. So it's going to be texted to you. In fact, let's just wait a second and see if you've gotten that. Oh. And while she's waiting, Senator Clark, would you explain what this document is?
Yes, Mr. Chair. I will again, and I realize that handouts make it more difficult for those that are remote, but we still have to do business. Arkansas Circuit Court Judicial Bench Book, Domestic Relations, updated June 2018, page 75. This is the handbook that the judges use without having to go back to an extensive law library.
Okay, Senator Flowers, did you understand that explanation that it comes from the Judicial Bench Book?
I understood that, but he initiated his remarks and what he was reading from as if he was reading from the statute.
Well, when you'll see the document here shortly, you'll see that the document does reference the statute, and I think that's part of the point he's trying to make. Have you gotten the document yet there, Senator Flowers?
Point of order.
What's your
Senator Garner? We do not interrupt senators presenting bills during the testimony. That is grossly inappropriate. Senator Clark should be able to elaborate on his point, and then she can ask questions during the question and answer portion. Mr. Chairman, we ask this committee hold to its rules, and that people participating one way or the other follow those rules. Thank you.
As I said to the previous point of order, we are going to make accommodations for people participating remotely to have the same access to the materials that we've had. That is a legitimate request. Senator Flowers,
that's not access to. No.
Senator Flowers, have you received the document yet?
Not yet. She said she's texting it to me. I haven't received a text.
We're going to also email it to you, and members, just be patient. We're going to allow Senator Flowers to get a copy of the document. Okay, Senator Flowers, we're also sending it to your email, so hopefully it'll come through in one of those avenues here shortly.
Thank you.
Senator Garner, would you like a copy of the document as well while we're waiting?
No, sir, I don't like to rudely interrupt the speaker. Let's continue.
Senator Flowers, just let us know if you receive that document. It should be either both texted and emailed.
I haven't gotten the text, and I'm looking at my Senate tablet, and I haven't received it. Let me refresh. I got it. I have it.
Okay, thank you, Senator Flowers. And again, both Senator Garner and Senator Flowers, let's allow Senator Clark to make his his presentation. Then we'll have a time for discussion as per normal. But we'll try to make sure that if there are things that need to be provided to those remotely, that we get that. And I guess moving forward, if you have something that you're going to present at the committee, you might let staff know to get it to those remotely in advance. But Senator Clark, thank you, and please proceed.
Thank you, Mr. Chair. If everyone is with me, presenting, I normally would not ask that question, but
I have to interrupt one more time. I was just reminded by staff, if you're going to participate in the meeting remotely, the rules do require that you turn on your camera. So Senator Garner, if you're going to participate, you need to turn your camera on. All right, Senator Clark, you're recognized.
The first asterisk, in an action for divorce, an award of joint custody is favored in Arkansas per 913-101. That was passed in 2013. Second asterisk, however, case law, both before and after adoption of code provision above, indicates that joint custody is not normally favored unless circumstances clearly warrant such action. Third asterisk, joint custody or equally divided custody of minor children is not favored in Arkansas unless circumstances clearly warrant such action. So, as I have met with Judicial Council and I have met with the bar, and if there was a way to make them happy, I would like to. Their chief objection has been not that joint custody is not a good thing, but that this law is too strong. Obviously, in 2013, the law was not strong enough, because although the law says, it is the law, that we favored joint custody, the book says, however, we don't. And what I'm asking you to do, and this legislature to do, is to change the law to where we do favor joint custody. And I'll be happy to answer any questions.
I have a question.
All right, Senator Johnson, and then we'll come to you shortly, Senator Garner. Senator Johnson, you're recognized.
And this is Senator Flowers has a question.
Yeah, got you in just a minute, Senator Flowers.
So, Senator Clark, through this presentation, so it's in case history where the judicial branch is favoring unequal treatment in custody. Is that right? Is that, I mean, that's the assumption I would make through this.
That would appear to be the reading of the book, yes.
So this would make, through legislative action and law, those parties equal in custody rather than case law. Is that?
That's my understanding, that the only way to correct case law is through actual law.
All right. Thank you, Senator Clark.
Okay, Senator Flowers, you're recognized for a question.
Okay, what Senator Clark just said about correcting case law through statute, I don't agree with that. I mean, you may change the result of future cases with similar facts. But you're not, I don't think we file bills to strike down a court case retroactively. But at any rate, I'll just ask my questions. You know, I've practiced in the field of family law, and it concerns me several things. One, on line 29 of your bill, where you are making an attempt to rebut this presumption that joint custody is in the best interest of the child, as you put in your language in line 24. And you say, or at the end of that line 29. So the other way to rebut the presumption that joint custody is in the best interest, you simply have to have the parties, if the parties, you say on line 30, to the action for divorce or petition to modify a child custody decree have reached an agreement on all issues related to the custody of the child, which seems to me that you are creating a situation where the parties alone decide the issue of custody, and without any court review or determination by the court that the welfare and the best interest of the child is served. And you also hear, with this language being so tight, we have other provisions of the code that allow a child to testify and give preference under certain circumstances, the age of the child and the ability to, speak up for themselves, to say what parent they prefer to stay with. And so that's cut out, it appears to me, by this language. And so we totally abandon the court in determining what it is that meets the standard that we've always had, which is the welfare and the best interest of the child. And then I was concerned about, on page 2 of your bill, line 12, well, it's line 8 through 12, and you add in here, you talk about the best interests of the child, the court should determine, and then you say a parent who is not granted sole, primary, or joint custody of the child is entitled to reasonable parenting time with the child, unless the court finds after a hearing that parenting time between the parent and the child would seriously endanger the physical, mental, or emotional health of the child. So I'm wondering, well, how is the court going to assess that? Are you going to need expert witnesses? What is it? Are you going to prescribe to the court what they have to determine whether the parent and the child's relation, the child would seriously be endangered physically, mentally, or emotionally? And also, I wanted to know whether
Senator Flowers, can we do one question at a time? So yes. Do you want him to respond to that one, and then we'll let you have an opportunity to ask now. So Senator Clark, you're recognized to respond to that question.
The first one.
Which question am I responding to, Sarah?
I'll restate my question for you.
Okay.
I'm concerned on page 1, the presumption, the rebuttable presumption that you create here. Line 25, you say how it can be rebutted. And then you have 2 situations that you create where it can be rebutted. And one is if the court finds by clear and convincing evidence that joint custody is not in the best interest of the child, and then you say, or 2, if the parties to the action for divorce or petition to modify a child custody decree have reached an agreement on all issues related to custody of the child. So my question to you is, your intent is to take the court out of the determination of what's in the best interest of the child and best for the child's welfare by that language, or?
Okay, let's let Senator Clark respond to that, and then again, try to go to the questions, and then we'll give time for for and against if we get to that. So, Senator Clark, you recognized to respond.
No, actually, it's not trying to take the court out. It is not at all unusual for the courts to allow the parties to try to resolve all kinds of areas of dispute, including custody, on their own before the courts make a decision, and that's simply putting that language in there. And so far, no one's had a problem with that language that says that a father and mother can decide on their own how they would like to arrange custody, and then the court would approve it, and that could be different from joint custody.
Okay.
As being one of the things that not be joint custody.
Okay, Senator Flowers, you have another question?
Right. I disagree with how he interprets that language, because I think it precludes the court from even reviewing if the parties to the action have agreed to all issues related to custody. So, and then the other one concerns the expert, or what kind of testimony or evidence would be needed for a court under your proposed bill to determine that the child would be seriously endangered physically, mentally, or emotionally by the parent in considering granting the reasonable parenting time. To me,
okay, so Senator Flowers, okay. So this is your second question about lines 8 through 12 on page 2, and what type of expert advice would the court use to come to that determination? Senator Clark, do you want to respond to that?
I don't know that expert advice would be required.
So okay. You would leave it up to the court to determine if a parent would put the child in serious danger, physically, mentally, or emotionally? I mean, what does that take? Just one parent saying that in the courtroom, or what?
A parent who is not granted sole, primary, or joint custody of his or her child is entitled to reasonable parenting time with the child unless the court finds, after a hearing, that parenting time between the parent and the child would seriously endanger the physical, mental, or emotional health of the child. If one of the parties feels like that the other party is going to parenting that child, having that child is going to seriously endanger the physical, mental, or emotional health of the child, then they're going to have to show some evidence of that. Whether that's expert or not, I'm going to leave to the courts.
Okay.
Okay, and then my last question right now, Mr. Chair, is does your bill and your intent include limiting or just repealing the ability of a child to state their preference? Under 913-108 of the code, the preference of a child can be considered if the child is of sufficient age and capacity to reason, regardless of chronological age. So are you just wiping that out too?
There is a rebuttable presumption that joint custody is in the best interest of the child, that both there was when I was 6 or 7, I would have favored being with my mother. When I was 13 or 14, I'd have favored being with my dad. I needed both my mom and dad at both of those ages. We'll leave the courts to interpret the language, but there is a rebuttable presumption that joint custody, that having both their father and their mother sharing custody, is in the best interest, unless they find an overriding reason to find differently.
Okay.
Or as in your addition to this subdivision on the first page, if the parties agree to do something related to all issues of the custody, which may not be in the best interest of the child.
Often government does not find what parents do with their children to be in the best interest of the child, but I tend to lean toward the parents and those issues.
Okay. Senator Ballinger, you're recognized.
Thank you, Mr. Chair. Senator Clark, nothing in this bill changes what evidence is presented in court. So a lot of times there will be a psychological evaluation, both parent, child, all that stuff. That doesn't take this out of the equation. So when the evidence that's presented, either to try to determine what is the best interest of the child, you haven't done anything to change any of that.
Nope.
So you've switched the burden just a little bit, although like we've seen, it's pretty consistent with what the courts typically do, but you've just established that as the burden. So things like, if there's a code section out there that specifically references the best interest or the child's preference, I've looked in here, you haven't deleted that anywhere, so that'd still be something that could be evidence considered by the courts.
Correct.
Right, and so the testimony of the parents, like if they actually have the parents on, people cross-examine, all that, the judge, the court, or if there's a jury, which typically doesn't happen, they would take all that in, the finder of fact would take all that in consideration.
Yes, thank you, Senator Ballinger. As we all know, if we had deleted any lines of code, they would be in here and have lines through them.
All right, thank you.
Any other questions from the members of the committee? Okay, we have 2 to speak for and 2 to speak against, so we'll start. Yep, Senator Clark.
Senator Hendren, those that are here to speak for, I've asked not to speak for. We do have some pretty compelling stories from fathers, but we're going to save those for the House end. Let those that want to speak against it speak here.
Okay, so Ham Singleton from the Judicial Council, if you'll come and state your name for the record, and you're recognized to speak against the bill.
Thank you again. Actually, my name is Hamilton.
Gotcha.
But it's too many syllables. You put it all together. The Judicial Council does respectfully object to this bill as it is presently worded. The Domestic Relations Code, divorce, custody, visitation, the burden of proof throughout that code is the preponderance of the evidence, the greater weight of evidence. This bill increases that burden of proof to clear and convincing evidence, which is just below, by the way, beyond a reasonable doubt that we have in criminal jurisdiction. It's too high a bar. It's a bar that cannot be attained by most lawyers, and it's certainly a bar that cannot be reached by self-represented personnel in domestic relations cases. So that, I submit to you, is something that is a major change in the code from what it is presently. The Judicial Bench Book, I'm glad you found it. It's a resource. It has no legal authority. We've attempted to visit with Senator Clark on this. We will continue to be available to visit with Senator Clark on this. Our concern is that if you focus only on joint custody to such an extent that you can't hardly get around that cluster of words, then you've taken the focus off what is in the best interest of the child. I submit to you as a judge, anytime joint custody is requested by a party in litigation, we have got to consider that. And if we do not agree with that, we have to set out facts and conclusions of law why joint custody would not be appropriate. And if we don't do that, they're going to reverse us at the appellate court. So we know what we have to do when we have a joint custody situation. Oftentimes, we grant it. But if it's not appropriate at the time, the higher burden of proof is just going to make it impossible for not only the parties, but I submit to you the courts to do the job that they're called to do, and that's to protect the best interest of the child or children.
Okay, we have a couple questions, Judge, and let me start, I guess, and again, as a non-lawyer on this, I'm learning, but as I look at this judicial handbook, it's a little bit shocking to me as a legislator to see written here, I guess, in guidance for judges that we know the law says this, however, case law says this. I mean, it almost sounds like the judge, this book is saying, we know the law says this, but the courts don't care. How am I misunderstanding that?
Because that's the current state of the law. When back in 2013, when this legislature thought that we needed to make joint custody the rule of the land, or the favored rule of the land, it was not the favored rule of the land. It was in the legislature, but it wasn't in real life.
But when the legislature makes the law, which supersedes, case law or what the statute actually says?
Oh, absolutely. If it's raised, Senator, it's got to be raised. If the issue for joint custody is not raised in a litigation, then there is no preponderance or clear and convincing evidence either way that we find joint custody.
Okay.
That request has to be raised.
Okay. I would argue that, again, we'll go to other questions, that the legislature has raised that in the writing of that statute in 2013. Senator Rice, you're recognized for a question. Then I think, Senator Flowers, do you have a question? Senator Rice, go ahead, and then we'll move on down that.
Thank you. And Judge, I think you heard my line of questioning to Representative Dalby, realizing that judges are human and sometimes do the best they can, and I'd say most of the time they do. In listening to this testimony, I revert back to what my question was before. What do you do when you have a case maybe that's difficult and you don't feel like it gets handled? When I have constituents that have come to me, not recently, have come to me and told me that they had, and the reasons they gave, I thought that a judge had to hear that. And because it's the best interest of the child. And the judge told them to basically shut up and get out of the courtroom because I felt like he had a bias. I don't know why he had a bias. Some people just rub you wrong. And I know that happens to judges.
I agree.
But you cannot get the best interest of a child if you don't have the information.
I could not agree with you more, Senator Rice.
And what I want to do is get it. Yes, you've still got leeway in what I understand in this law, but I would agree with Senator Clark. What happened in the previous years, 2013, evidently didn't go far enough. And so,
well,
I would welcome your response.
Well, I'm sorry, I disagree. I practice domestic relations in all 6 counties of our district, as well as criminal and union and probate in all 6. Whenever I receive a domestic relations custody case, whether it's original on divorce or it's post-decree change of custody, and they are seeking joint custody. Anybody is seeking joint custody. I will consider that argument. I've got to consider that argument. I am charged by 913-101 to consider that argument, and I will address that argument, and I will, if it appears to be the correct thing to do for a child, I will endorse it. But if it does not appear from the evidence to be in the best interest of the child by a preponderance of the evidence, then I would be neglecting my job to force a joint custody where it doesn't fit. And I will give the reasons why it doesn't fit in my decision, so that then the appellate court can review it, decide it, see if I've made a reversible error on that. But again, taking it from a preponderance of the evidence to clear and convincing evidence is a huge, huge increase in the burden of proof. You're asking a party to rebut joint custody, not by a preponderance of the evidence, but by clear and convincing evidence, and you won't find that anywhere else in divorce code or in custody code or children born out of wedlock.
And just to follow up, agreeing that there has to be leeway for judges, but I think you know what happens when you've got an attitude that this is my courtroom, because we've had legislators told they couldn't be involved before, and when they will not hear critical evidence, critical statements from family members, whatever, they can dismiss them if they want to. There is no way that I feel a judge can be fair. And again, biases happen. Cliques happen. Good old boy, buddies happen. And people are not able financially to go up the ladder to appeal things. So I feel like we've got to do something to make clear what law is and what law is to be followed. Thank you, Mr. Chair.
Okay.
Let me make a quick response to that. Senator Rice, I know that we have maybe some judges, hopefully they're in the minority, a very low minority, who have let the robe go to their head. And I'm sorry. I'm sorry that someone's had that experience. If you have, then report them. I mean, the idea is not to create a law that is going to derail what every other judge is trying to do on behalf of joint custody. Instead, let us do our jobs and report that judge who has not been receptive, who will not talk to you, who obviously on the record has committed some problems. The very last time I was here, I think, was with you, Senator Stubblefield, regarding a judge, a special judge that came in and was creating all kinds of problems. And I agreed with you that was wrong. They need to be cleaned out. But don't make the rest of our jobs any harder by creating a burden that just cannot be met. Thank you.
Okay, Senator Flowers, you're recognized for a question.
Yes, and this is to Judge Singleton. And I would also say not only does it make the judge's job harder, but it may wreak havoc on the child's life. But my question to Judge Singleton is concerning that or on line 29, I'd like to know what your interpretation of being able to rebut the presumption is taken away if, as in subsection 2, it says if the parties to the action basically agree or have an agreement on all the issues related to the custody of the child. Does that preclude any further deliberation concerning whether the presumption has been rebutted or can be rebutted? And does it take the court out of determining what's in the best interest of the child and the welfare of the child?
Judge.
Senator Flowers, as I appreciate your question, when the parties have reached an agreement for custody and visitation, we do our best to accommodate them on that. That does get you around the hurdle of rebutting the presumption. But the problem is if they don't get there, then the presumption has to be rebutted by clear and convincing evidence instead of a preponderance of the evidence, which is too great a burden for most lawyers on behalf of their clients and for self-represented clients to even get to. I will tell you that there are judges in this state, good judges, who do a really, really good job, that when people bring them joint custody agreements, they will sit those parties down and take them through a litany of questions to be sure they understand exactly what joint custody means. It doesn't mean, it's not just that you get to see Junior's school records. It means you have to take an active interest in that child and raising that child and supporting that child. Others don't. They just, if that's their agreement, they're good with it. But did that answer your question?
Well, I'm concerned about the court even having the ability to review that agreement with the mindset of determining what is in the best interest of the child and the child's welfare. I've seen cases where parents can be rather nefarious in terms of their agreement. They may have other motivations for reaching an agreement as to joint custody, which is not always in the best interest of the child.
It happens all the time, especially when you have joint custody and no child support.
Well, I mean, we have been.
And the whole thrust is to avoid the issue of child support. I won't challenge custody, make it joint custody, and I won't pay child support. It's a problem. It's a problem.
Okay, Senator Flowers.
Thank you.
Yep. Senator
Yes.
Ballinger, did you have a question? Senator Johnson, you're recognized for a question of the judge.
Judge, I mean, the argument that you've put forward is the preponderance of the evidence in the presumption against the clear and convincing evidence. And it is a higher standard, but in this bill and in the opinion of many, that equal custody or joint custody should be considered first, and the preponderance of the evidence. Tell me how it would be different. You know what I mean? And the child's welfare be better being something besides joint, and that threshold should overcome the equality and the jointness of that child's care. I know there's good parents and bad parents, but also, you know, through that evidence, you can weigh that.
Absolutely.
I mean, I as a lay person, I see what you're saying, but can you give an example of preponderance of the evidence compared to clear and convincing evidence. Because to me, the child's best interest is an equal partnership in raising that child, unless there's good reason not to.
Let me give you an explanation of what clear and convincing evidence is. It is proof that enables you, without hesitation, to reach a firm conviction that the allegation is true. Without hesitation, to reach a firm conviction that the allegation is true. Preponderance of the evidence means the greater weight of evidence. 51 or 50.1% of the evidence. And that is where we are currently in our domestic code, is preponderance. The clear and convincing, again, takes it way high, way high. And I submit to you, it's a burden that I tried to establish can't be made by self-represented clients unless they're wizards, and can't be made by most lawyers on behalf of their clients. And I think maybe the bar is here to address this as well. And they're really in the business of burdens of proof. I'm just there to decide. They perhaps could give you a much better explanation than I.
We will have a representative of the Bar Association here shortly. Senator Johnson, you finished? Senator Clark, you have a question?
I do. Thank you, Mr. Chair. Judge, I get more calls on child welfare, custody, et cetera, than everyone in this room put together. And I get more calls from others on those issues. But on this issue, I get more calls from dads, 5 to 1, 6 to 1. And the calls come from professional dads. They come from policemen. They come from veterans. They come from attorneys. They come from doctors. And they come from all walks of life. And does it surprise you that many fathers feel like that they're not getting a fair shake in custody cases when it comes to joint custody? Because are we awarding, if it's not joint custody, are we awarding custody to fathers that often? Or is it going to be mothers or joint custody most of the time?
You would be amazed at the number of...
Get a slide forward a little bit so that the microphone...
My bad, Thank you. You would be amazed at the number of fathers to whom we do award custody, for all the various reasons.
By amazed, what would be an amazing number?
I would submit probably Senator Clark in the last 4 years, I've awarded emergency temporary custody to fathers 2 to 1.
But I'm not just talking about in your court, and I'm talking about across the state.
I can't help it. I mean, I can only tell you what I know.
Well, because I didn't say I'm getting calls from your court.
Thank you. If you do, you know my number. Please call me.
I said I'm getting calls, and I'm not getting, I mean, we come back to that issue. This is about joint custody, but we come back to that issue. I'm not getting calls from mothers who've been accused of sexual abuse wrongly, who have been accused of other abuse wrongly to get a foot up in the system. It's not that it doesn't happen, but it happens way more on the other side. And again, I see a great disparity because if it was on the shoe was on the foot, I'd be arguing for mothers, but the shoe's not on the other foot.
I think Senator Clark, if I hear what you're saying, you want to have fathers to have a chance.
That's what
you want fathers to have an opportunity.
That's what this legislature wanted in 2013.
And I'm telling you, if they request joint custody and they supply proof of of the need for joint custody, it's going to be addressed. And it will be addressed, I mean, clearly. But increasing the burden of proof doesn't make that any better. In fact, again, it probably frustrates it. Frustrates it much worse than it was before.
Thank you, Judge. Thank you, Mr. Chair.
Okay, that's all we have for questions. Thank you, Judge.
Thank
Next
you.
on to speak against the bill, we have Angela Mann from the Arkansas Bar Association. So again, if you just state your name for the record, and you're recognized to speak against the bill.
Thank you. Is my microphone on?
Yes, ma'am.
Okay. Good morning. My name is Angela Mann. I'm an attorney here in Little Rock. And I'm here on behalf of the Bar Association. I'm a former chair of the Family Law Section, and I volunteered to work with the legislature this year to help hopefully pass some laws that can help litigants in family law courts. In connection with Senate Bill 18, I have a lot to say. If I say too much, somebody tell me to stop. But the consensus among attorneys is that all oppose the proposed legislation as written. There are three main concerns that I want to talk about. One is the burden of proof, and Judge Singleton has talked about that quite a bit, so I'll try not to talk too much about that, but I do have a little to add. The concern that has not been addressed yet is the fact that there's a presumption at all. And then Judge Singleton and several senators in your questions have raised this issue, but the bill as written shifts the focus away from the best interest of the child, which is the primary consideration in all custody determinations. Judge Clark, you and I have spoken quite a bit about this bill and other related legislation, and I appreciate your willingness to consider the bar's position. And I hope that we can continue discussions to work something out that works for all of us. I want to talk first about the law the way it is now. Arkansas Code Annotated 913-101 currently states that joint custody is favored. That law was changed in 2013. The focus of the law as written is the best interest of the child. And the court does have a starting point, which is joint custody, but still has absolute discretion to determine the proper custodial arrangement based on the best interest of the child or children in each particular case. And I want to point out that the statute already has the following language. In an action for divorce, the award for custody of a child of the marriage shall be made without regard to the sex of the parent, but solely in accordance with the welfare and best interest of the child. Further, when in the best interest of the child, custody shall be awarded in a way so as to assure the frequent and continuing contact of the child with both parents consistent with subdivision A1A above. And to this effect, the circuit court may consider awarding joint custody of a child to the parents and making an order for custody. The same rules also apply in paternity cases, and that hasn't been addressed yet, but Arkansas Code Annotated 910-109 addresses paternity cases where the parents were never married, and specifically states that subsequent to acknowledgement of paternity by the parties or an adjudication by the court shall follow the same guidelines, procedures, and requirements as set forth in the laws applicable to children born of the marriage and awarding custody, visitation, and support. So any amendment to 913-101 would necessarily apply not only to custody of children pursuant to a divorce, but also custody of children to parents who were never married. Now, I want to talk about a presumption because as a lawyer, this is a big deal to me. So what is a presumption, and why is a presumption of joint custody not in the best interest of children? Black's Law Dictionary defines a presumption as a legal inference or assumption that facts exist based on known or proven existence of some other fact or group of facts. A presumption shifts the burden of production or persuasion to the opposing party, who can then attempt to overcome the presumption. So a presumption it's not just a starting place of joint custody. It assumes facts that don't exist, or that may not exist. A presumption of joint custody assumes that joint custody is in the best interest without any evidence whatsoever that either parent is fit to have custody. And as I stated at the beginning, presuming that joint custody is best for all children shifts the focus away from the children. This hurts the Arkansas children. It hurts Arkansas families. And in my opinion, it hurts good parents and bad parents. It creates increased litigation if joint custody is presumed to be the best thing in every case. Best interest is just not something that can be assumed. Judge Singleton talked to you a little bit about how he would determine best interest of the children. And adding a presumption, it makes judges assume that joint custody is in the best interest and takes away that decision-making from the courts. Let me give you some examples. The presumption in the statute as written would assume that a drug addict mother should have joint custody. It would assume that an abusive father should have joint custody. It would assume that an absentee parent have joint custody. What about children that have been raised by their grandparents? It assumes that mom and dad, not grandparents, should have custody. It assumes that it's in the best interest of children to have joint custody when one parent lives 2 counties away. It assumes that joint custody is favored in situations where one parent may not have a home, one parent may not have electricity. It has no exceptions. It starts by requiring the court to assume that joint custody is best. And we do have presumptions in our domestic relations law. As Judge Singleton mentioned, these presumptions are triggered by a preponderance of the evidence. Arkansas Code Annotated 913-101C and D provide a presumption that it's not in the best interest of children to be placed in the custody of a parent who is engaged in a pattern of domestic abuse or who has been registered as a sex offender. And to get to that presumption, the standard of proof is preponderance of the evidence. So not only is that somewhat disjointed with the proposed amendment to the statute, it's also a completely different standard, a more appropriate standard of preponderance of the evidence. And more importantly, I want to address Senator Clark has talked quite a bit about the bench book, and y'all have asked lots of questions. As a lawyer, I've never read that. I read the laws that y'all write. I read the case law as the Court of Appeals and Supreme Court interpret those laws, and I don't read that. And perhaps that needs to be changed, but the bench book is not the law of the land. The statutes and the case law are the law of the land in Arkansas. And Arkansas courts have recognized that joint custody is favored, and they have interpreted that statute as amended in 2013 as a profound change in the law. I want to talk about Pace versus Pace. It's a 2020 Arkansas Supreme Court case, and I'm going to quote the Supreme Court. In addressing joint custody, the Supreme Court states, "We note first that in 2013, the General Assembly amended Arkansas Code Annotated Section 913-101 to announce that an award of joint custody is, quote, favored in Arkansas. Previously, case law held that joint custody was not favored unless circumstances clearly warrant such action. This change in the law is profound. The parties are no longer obligated to maintain a careful balance of cooperation to stave off a judicial dissolution of joint custody arrangement. And this law has spawned a change in the approach that courts take, as manifested in Hoover versus Hoover, which is a 2016 Court of Appeals case, where the Court of Appeals affirmed a circuit court's decision to lessen conflict by modifying the contentious provisions of a custody decree rather than scrapping the joint custody arrangement. And in practice, courts are doing that. In my practice, I practice primarily family law. My office is in Little Rock, so the majority of my cases are in Central Arkansas, although I do practice around the state. But courts are doing what Senator Clark desires with this proposed legislation. Courts are already starting with joint custody. Like in Hoover, courts are awarding joint custody even where people can't get along. Courts are awarding joint custody in cases where the parties can't even be in the same room. I've seen orders where courts award joint custody and specifically make it to where the parties don't even have to discuss decisions regarding the children. They have the children half the time. They each have about 50% say, but they are never in the same room as each other. So courts are going out of the way to make joint custody work, but it doesn't always work. And courts need the discretion to do that. I don't know the facts of each and every case. I understand the concerns of the constituents that have reached out to Senator Clark. I have male and female clients with the same complaints. But we have 30 new judges in the state of Arkansas that were sworn in this month. Most of them are young in their 40s and 50s. They bring a different approach to the bench. So we can't take away their ability to determine what's in the best interest of children. We can't legislate away the issues that people in the past have faced. We can't, and I think Senator Johnson may have mentioned that, we can't enact legislation to retroactively fix things. The statute, we especially can't legislate away decisions from prior to 2013 when the statute was amended. The burden of proof, I want to briefly talk about that, although I think Judge Singleton did a good job addressing the burden of proof. But as Judge Singleton said, clear and convincing evidence has no place in domestic relations law. You don't see it in the domestic relations statutes. The only time that I'm aware of where you see a clear and convincing evidence standard as it relates to children is when we're talking about terminating parental rights. It's such a high standard that most custody cases, probably 99% of custody cases, are not decided by that margin. Most people, as Judge Hamilton mentioned, pro se litigants will never be able to meet that burden. Litigants with attorneys will likely only be able to meet that burden with expert witnesses to prove to meet that burden of it's almost beyond a reasonable doubt, which that's a term that I think people are more familiar with. Clear and convincing evidence is just one step down from that. And so, we have to have expert witnesses. We have to have custody evaluations by PhD psychologists. We have to have psychiatrists. We have to have, everybody under the sun come in to testify to meet this burden. It's just too high. It's going to increase litigation. It's going to make it to where we end up with, I feel like it's going to handcuff judges where they have to give joint custody where they otherwise would have never considered it. One thing that I noticed from this discussion with Judge Singleton is this statute presumes that everybody wants joint custody. When we file a divorce complaint, when we file a paternity case, when we file a modification, we ask for what our client wants. There are a lot of people who don't want joint custody, but this statute presumes that that's in the best interest of their children. Now, I think it's important to make sure that the courts are starting with joint custody, and I think they are, and perhaps we need to amend the bench book. But I don't think we need to overhaul the entire statute and change the burden of proof, change the way custody cases are tried, change access to the court system even. Sometimes one or both parents aren't fit. And while I agree with Senator Clark that fathers are important, they're not the most important thing in a custody case. The most important thing in a custody case is the child. And handcuffing the judge by saying both parents are fit, both parents get joint custody as the starting position with this extremely high burden only hurts children. Now, I took a couple of notes, and so if I repeat myself or go backwards, I apologize. Senator Clark mentioned that the bar's objection is that the statute is too strong, and I think that's not exactly accurate. Our position is that the statute goes too far. It ties the hands of the court. It imposes a super high burden, and the statute as written, and as currently interpreted by the courts already does what everyone in this room, I believe, wants. Let's see. Okay, I will answer questions at this time if anybody has any.
Okay, thank you, Ms. Bannon. I'll start with a similar question that I asked the judge, but because again, are you familiar with this handout that Senator Clark gave out with the judicial benchmark?
I'm looking at it now, Senator.
So if you look under joint custody, the second, third, and fourth paragraphs are just, I have a hard time reconciling that because I think what I hear from the courts is this is an overreach and going too far with the law. But when you look at this handbook, it looks like the courts are basically saying the legislature said this, but nah, we're not doing that.
And I understand that concern, and this concerns me too as an attorney. I think, you know, in an action for divorce, an award of joint custody is favored, and that's the way it needs to be left at that. Everything below that appears to be an interpretation of the law prior to 2013. And
so you can understand why it promotes this type of response when you see a handbook issued to the courts basically saying we're going to set aside what the legislature said the priority was.
Yes, Senator, and I do understand that concern. Fortunately, this is not the law in Arkansas. The law in Arkansas is the statute as amended in 2013 and the case law interpreted by the Supreme Court as recently as 2020, stating that we start with joint custody. And so this bench book needs to be rewritten. It's wrong. But that doesn't mean that we need to completely overhaul the entire system.
Okay. Senator Johnson, you've got a question?
In speaking earlier, you know, in this process, you said, you know, we've tried joint custody in cases and said, you know, it's clearly not working. So in my interpretation, that meets the burden. If it's clearly not working, then you've met the burden of clear and convincing evidence to yourself as a judge. It's clearly not working. But I don't understand the thought that equality in parenting, no matter what the circumstance, whether it's a drug abuser or whatever, because that's pretty clear. There's one better than the other possibly. You know, and that would be clear and convincing to me if I was a judge in that case. Now, I have never sat there, but, you know, my black and white don't run into gray very often. So, I mean, that may be the difference between me and the practice of law, but there's a discipline and a responsibility in all justice. And whenever that equality in parenting is taken away from one, that responsibility is taken away from that side, and that parent may never question itself to better itself if always put in a position of 20% custody. But where is if that responsibility is laid on that parent at half, you've got to take care of this child you made, and it's your responsibility now. Do you see the bearing of that helping that individual become a better parent and become a better citizen and help our whole situation through that responsibility, rather than just discipline and say you're 20% good or 10% good or 2 hours a week? That responsibility of presuming that you are going to be 50% responsible for this child you helped create. Do you see the weight of that? Because I felt it whenever I became a parent. But I prepared myself, and I was responsible along the way. But if we continually remove responsibility, whether it's in this situation or others, you're not making better people and better responsible citizens through their own self-correction. So, I feel like there should be equality in the beginning, and you say that's what you see, but that clear and convincing evidence may be clearer to me because I hadn't been muddied. You know what I mean? If it's clearly not working, and that parent has continued to be a bad parent, then I feel like that's whenever the judge can step in and, that the parent that is seeing that, the other 50% says, this knucklehead is clearly not working. So it comes back before the judge, and then he can clarify that. But in the beginning, that first step should be towards responsibility, and let them take that on and see if they become better people.
Okay. That was a lot, so I'm going to try to address as much as I can, and if I miss something, just ask again, okay? Most importantly, nothing is black and white in law. Everything is gray. And I'm sure you've heard that 10s don't marry 1s. That's what we're dealing with in court. You don't have a model parent who has no flaws, and then somebody who is very clearly a bad parent in every case. They're usually both kind of around the middle, but one is definitely better. But it's not definitely better without hesitation. You know that's the right decision every time. And so clear and convincing evidence, it's just too high of a burden, and we don't see it anywhere else in our family law statutes because it is too high of a burden. It ties the hands of the judge. And, you know, while I appreciate your goal of making responsible people, that focus isn't on the children. The focus has to be on the best interest of the children, not the best interest of a parent. And a parent who gets the child 20% of the time and says, fine, I'm not going to deal with that, then that's not in the best interest of the child to make that parent be with the child 50% of the time. And if we have to start with joint custody and wait till that parent fails and the other parent can go hire a lawyer and go back into court, we're increasing litigation and we're harming the child in the process, potentially.
That answer your question, Senator Johnson?
I appreciate your position.
Okay. We don't have any other questions.
I have a question.
Senator Flowers, you're recognized for a question.
Thank you. I agree with the witness in terms of this bill, if it became law, limiting the ability of the court to determine what we've always had as our standard, which is the welfare and the best interest of the child or children. And I would like to know if you agree that this bill would create more contradictions in the law and might make some provisions that we have in the law, such as the child's preference to live or be under the awarded, their custody awarded to either parent, their preference would be not considered necessarily, particularly in the event of an agreement between the two parties as to all the issues related to custody. And so I'd like for you to respond to that, the preference of the child, as well as this line 29 and the or at the end of that line, that the presumption can't be or is not going to be rebutted if the parties agree. Do you believe that would take out the authority of the court to review custody at all?
All right, Senator Flowers, I'm going to address your last question first because I think it's the easiest. And I think that courts do have the ability to accept agreements by the parties. And I think that this statute as written is missing one important piece, which it needs to be approved by the court. Because
exactly, that's my point. The court doesn't have to approve this agreement with that language or.
That's correct. And so I think that needs to be amended if the parties agree to something other than joint custody. That can rebut the presumption, but it must be approved by the court. The court must find that agreement is in the best interest of the children. Courts don't always rubber stamp a party's agreement. I don't think that they should, because sometimes people agree to things that aren't good for children. So I think there's an easy solution to that concern by requiring that the courts approve an agreement by the parties after finding that it's in the best interest of the children.
Okay, well, we don't have the easy solution before us. We are looking at this bill as it's written, Senate Bill 18, with that language. And so my question is, would that word "or" take away the court's ability to even review an agreement to determine whether it's in the welfare and the best interest of the child?
Senator Flowers, I think that it might. The statute does say may, so I think the court would still have discretion under the statute. I do see your concern, though. It does create uncertainty, and that's my concern with a lot of this bill, that it creates a lot of uncertainty. It appears to tie the hands of the courts in ways that probably aren't intended, and I think the effect of that is going to be increased litigation. It's going to put kids in situations that aren't in their best interest without proper consideration.
Exactly. And then the other question was concerning the preference of the child.
Sure.
Whether that would be limited by this bill.
Your Honor, or not Your Honor, I'm sorry. I'm so used to being in court. Senator, I think the preference of a child is a factor that the court can consider, which would probably remain a factor that the court can consider. I know some courts, we don't have a magic age in Arkansas, which I like. And I think that a lot of children do have strong preferences, and I think that a lot of children do have reasons for wanting to have joint custody. I mean, children, in my experience, they don't want to choose sides, and children do tend to say, I want to be with both parents more often than not. I'm not going to say it's 80% of the time, but more often than not, when you ask a child where they want to live, they say, oh, I like both parents. I don't want to pick. But I think that that's a factor that should remain in there. I think there are other conflicts that are created by the presumption, though, including the presumption that it's not in the best interest of the child to be placed in the custody of a parent who has committed an act of abuse or domestic violence or is on the sex offender registry, because we only have to prove that by a preponderance of the evidence. So if we can only prove domestic abuse by preponderance of the evidence, but we have to prove that it's not in the best interest for joint custody by clear and convincing evidence, then those two things, they don't mesh, and you can't. You might meet the burden of proving domestic violence or the sex offender status by a preponderance of the evidence, but not be able to meet the higher burden.
Thank you.
Thank you.
Okay, Senator Stubblefield, you're recognized for a question.
Thank you, Mr. Chairman. I just want to say that, Judge Singleton, if I knew that every judge was as noble and virtuous as you, I could understand voting against this, but I have witnessed with my own eyes that not every judge is as noble and virtuous as a lot of other judges. There are some bad judges out there. I know, because I've sat in their courts and I've watched their verdicts. And a lot of that, Mr. Chairman, I want to make a motion for immediate consideration.
Okay, we don't have anybody else to testify or any other questions, so I'll accept that motion for immediate consideration. All in favor, say aye. Aye. Any opposed? Okay, so now the motion is to do pass as amended. Do we need a motion for do pass as amended? Got a motion and a second. All in favor, say aye. Aye. Motion carried. All opposed?
No.
Okay, motion carried.
Can I have a roll call?
Okay, we've got a request for a roll call vote. And Senator Garner, you're going to need to turn your camera on for the vote. Go ahead.
Senator Stubblefield.
Aye.
Senator Rice.
Aye.
Senator Blake Johnson.
Aye.
Senator Blake Johnson votes aye. Senator Garner.
Yay, yes.
Senator Garner votes yes. Senator Ballinger.
Yes.
Senator Ballinger votes yes. Senator Flowers.
No.
Senator Flowers votes no. Senator Clark.
Uh,
Senator Clark votes yes.
be an aye. So the motion has carried, 7-1.
Thank you, Mr. Chair. Thank you, committee.